remind our committee members of your background, and then you will be able to do so as well. But you rose to become the top-ranking civilian contracting official in the U.S. Army Corps of Engineers, as I understand it. And I have a statement that you made previously to this committee, and I want to put it up here because with respect to some of the contracts that were provided to Halliburton and some others, but especially the Halliburton contracts, here is what you said to this committee. I can unequivocally state that the abuse related to the contracts awarded to Kellogg, Brown & Root, the subsidiary of Halliburton, represents the most blatant and improper contract abuse I have witnessed during the course of my professional career. You testified publicly to that after you had complained internally in the Department of Defense about what you felt was happening, that you felt was wrong, blatant abuse of contracting laws. Before you testify, I want to say to you that those who demoted you in the Pentagon said that your performance was not good performance. I recognized and got the information that you had also always had outstanding performance recommendations prior to the time that you began to call attention to improper or abusive practices. I called, incidentally, one evening here about 2 months ago, the former commander, General Ballard, from the U.S. Army Corps of Engineers, now retired, who you worked for, who hired you, and asked him about you. And General Ballard says this: she did an outstanding job. So that's from the person that ran the U.S. Army Corps of Engineers. You apparently did an outstanding job until you blew the whistle and said what's happening is blatant abuse. For that, you have apparently paid dearly, and I regret that, and I have spoken to Secretary Gates, spoke to Secretary, trying to remember the last Defense Secretary, Rumsfeld. It's funny how you forget a name. The Secretary Rumsfeld. I've spoken to Assistant Secretary England, and no one provides answers to what they have done in the Pentagon to you for your courage. But I didn't mean to go further than that. Bonatine Greenhouse is a former civilian chief of contracting. You got into a lot of trouble, got demoted, removed from the senior executive status after you raised concerns about contracting abuse. Why don't you proceed, Ms. Greenhouse?
Yes, thank you. My name is Bonatine Greenhouse. I thank the committee for allowing me to appear here today. As you may be aware, I was the United States Army Corps of Engineers' top procurement executive. A career spanning over 23 years ended on August 27, 2005, when I was removed from the senior executive service and from contracting. I was removed after I raised concerns over the award of a $7 billion sole source no-compete cost-plus contract to Halliburton subsidiary Kellogg Brown & Root, KBR, known as the Restore Iraqi Oil RIO contract. The award of this contract represents the worst contract abuse I witnessed during my professional career. Before the contract was awarded, I voiced great concern over the legality of the selection of KBR, the total lack of competition, and the excessive duration of the RIO contract. I explained to representatives from the Department of Defense, the Department of Army, and the Army Corps that granting a contract for 2 base years with the potential to extend the contract for an additional 3 years was simply unconscionable. In October of 2004, I received notice that I was going to be demoted and removed as the Army Corps' procurement executive. At that juncture, the concerns I had over the award of the RIO contract were brought to the attention of members of Congress and the public. In response to the substance of my concerns, the acting Secretary of the Army directed that my concerns were to be referred to the Department of Defense Inspector General for review and action, and that I was not to be demoted and removed from the SES until a sufficient record is available to address the specific matters I had raised. Yet, the DoD IG has failed to conduct any investigations of my concerns. In June of 2005, I was asked to appear before the committee, and I agreed to do so, Just prior to my appearance, the Army Corps' acting general counsel let me know in no uncertain terms that it would not be in my best interest to do so. I ignored this threat to my professional career, and swiftly thereafter I was removed from the SES and from contracting. Things have not fared well for me since then. After having a full year to figure out where I should be placed upon my demotion, I was directed to report to the Army Corps' Civil Works Engineering and Construction Division. The horrific breach of the New Orleans levees commenced less than 24 hours from the time I was directed to report to the Civil Works Division. The response to the Katrina disaster was one of the largest contracting civil works efforts the Army Corps has ever faced. But the Corps had no leadership in contracting. And SES was moved into my position, who was not a contracting careerist and had not served a day as a contracting officer, and had to seek a waiver for the experience and training requirements that were established by Congress. On the contracting side, I was recognized as the most knowledgeable and critical thinking contracting professional within the Army Corps, yet there was no role for me to play in response to Katrina. On the civil works side, I am a Defense Systems Management College certified program manager with a master's degree in engineering management from George Washington University and a War College master's degree in national resources strategy, a master's degree in business management. Yet, there was no role for me to play in the face of the Katrina disaster. Instead, I was systematically excluded from Katrina management meetings that were held in my office area behind closed doors. I was born and raised in Louisiana, and it pained me greatly that I was not permitted to assist with the Katrina disaster. The only reason given for having failed to give me performance standards for 9 months was that my supervisor was too busy responding to the Katrina emergency to give me something to do. I do not believe that for 1 minute. Since my demotion, I've experienced isolation. I continue to receive inappropriately downgraded performance reviews. My top secret clearance was withdrawn. Individuals have attempted to take credit for my work. No training opportunities have been identified, and I have been prevented from returning to my contracting career field. Additionally, I had to fight off efforts to cripple the Defense Base Act DBA insurance pilot program that I brought into existence. The Congressional Budget Office has recognized the benefit of my DBA insurance program, which saved the government $45 million in the first year alone. The intensity of the battle that I had to fight to maintain the DBA insurance program leads me to believe that the Army Corps was willing to sacrifice the program than allow me to garner credit for its success. Finally, it is paramount for this committee to recognize that my removal has caused a deep chill to descend over the government contracting community and the SES Corps. Contracting officers now know that speaking up against contracting abuses will not bring them praise, but can cost them their jobs. Thank you.
Ms. Greenhouse, thank you very much. Thank you for your courage, and thank you for being here today as well. Mr. Robert Isaacson is a former Coalition Provisional Authority contractor, founder and current managing director at DRC, Inc., a project management construction and construction management firm in Mobile, Alabama. Previously a special agent with the FBI for 10 years, supervisor in charge of white-collar crime and political corruption in Louisiana. Mr. Isaacson was also one of the founders of a trading and contracting firm, a construction and life support service company founded in Kuwait and directed its international operations from its inception. Mr. Isaacson, welcome. Thank you very much for being here, and you may proceed.
Thank you, sir. Honored members of the Senate, thank you. Thank you very much for the invitation to testify here today. I'm a former special agent supervisor with the FBI. as you said, in charge of white-collar crime and political corruption for the state of Louisiana. When I left public office, I established a disaster recovery business in Mobile, Alabama that has become very successful. I am pleased to say that we have helped many people in their times of greatest need. In 2003, we went to Baghdad in order to help the people there and to assist in the reconstruction of the country. We won a subcontract working for an American company called Custer Battles. Custer Battles obtained a contract with the Coalition Provisional Authority at BIAP, Baghdad International Airport, that allowed it to submit its costs to the government and get paid for all of those costs, plus 25% profit and overhead. Rather than bill for its real cost, this company billed for a substantially higher fraudulent cost. They asked me 3 times to assist them preparing fake invoices and leases that they could then submit to the government. The first time I told them no. The second time I told them hell no. The third time, after telling them no, I told them they were all going to prison. As a result of my continued refusals to cooperate in their fraud, they pointed machine guns at us, stole our weapons, and seized our identifications. While our brave men and women in uniform were fighting and dying for our safety and liberty in Iraq, these former U.S. Army Rangers and CIA officers were accosting witnesses to their proposed fraud, forcing them to be held at gunpoint, disarming them so they could be conveniently killed in Iraq by the insurgents. Custer Battles left us to fend for ourselves in the streets of Baghdad. We drove that night from Baghdad through Fallujah, the renowned Valley of Death, the only route to Jordan in safety. Later, I learned that this company had handed in $10 million in fake invoices for approximately $3 million of work. We informed the government of what happened prior to our leaving Baghdad and subsequent thereto. Another witness joined us, a good man named Pete Baldwin, who had worked for Custer Battle, but just could not stomach the fraud. He was fired when he refused to participate in their illegal activities. Together, we were cooperating with the FBI and the Department of Defense, CID. However, when we felt that the fraud was continuing and the investigation was bogged down, we decided that the only thing we could do was to seek action ourselves. Something had to be done to stop this multi-million-dollar fraud before it got bigger and bigger. My lawyer here, Mr. Grayson, filed a whistleblower lawsuit against Custer Battles. The FBI and DOD investigative agents were professional, thorough, and dedicated. However, as hard as they tried, they could not get prosecution initiated. The DOD ultimately suspended Custer Battles and some of the principals. However, to date, no one has been indicted, and the federal government has refused to join in the Ketam false claim suit. We pressed ahead with the case, spending hundreds of thousands of our own money in the process. We won our breach of contract claim against Custer Battles, and Pete won his retaliation claim for his firings. We then obtained a jury award of over $10 million on behalf of the U.S. taxpayers. To date, the largest award of a whistleblower case against any contractor that the government declined to become involved in. The judge later ruled that the money Custer Battles stole from the CPA, the Coalition Provisional Authority, might not technically be the funds of the U.S. government, although it was provided by the U.S. government in $100 packets of $100 bills, as you showed. So he reversed the jury verdicts for the taxpayers, and that ruling is now on appeal. I am happy that the law gave a whistleblower like me the chance to step forward, stop on going forward in its tracks, and try to get stolen money back for the U.S. taxpayers. I always felt that it was the right thing to do, but many times I wondered, why should I do all of this to help the government when the government is doing nothing to help us? Deuteronomy 32:38 states, "Let us rise up and help you and be your protector." No one in the government rose up to help us or provided any protection for us in this endeavor. Not only did we have to spend our own funds and time to prosecute this case, we also had to endure the unrelenting attacks and slander from our opponents. We were sued repeatedly. We've been the subject of anonymous blogs and lies on the internet and anonymous fraudulent emails and documents. 2 Corinthians 13:7 tells us that we should do no evil, and we should do that which is honest. That's how I run my life, and that's the underlying principle of how we run our business. This is the 4th time since I've been in private business that I've observed fraud against the government, and the 4th time that I've reported it. One of those instances resulted in a conviction of a very high-ranking government executive for bribery, another the firing of a senior government executive for fraud, and this one in a successful Ketam jury verdict. However, each time, instead of being complimented for doing our civic duty, we are then ostracized by individuals inside the affected agency for years to come, denied contracts, have become the subject of false allegations by the very agencies we've tried to assist, or were left to personally fend off the unrelenting attacks of the persons whom we reported, who were using the very funds they stole from the U.S. government to fund their attacks on us. Thank you very much for this opportunity to shed light on these issues. God bless this august body. God bless America. And please, God, bless our fighting men and women in Iraq. Thank you very much.
Mr. Isaacson, thank you very much. Thanks for your courage and your honesty and your willingness to come forward. Mr. Stephen Kohn is the Executive Director of the National Whistleblower Center, one of the nation's leading experts on whistleblower protection laws, and the author of the first legal treatise on whistleblowing. Mr. Kohn is a partner in Kohn and Colapinto law firm, and he serves, as I said, as the Executive Director of the National Whistleblower Center. Mr. Kohn, you may proceed.
Thank you very much, Senator Dorgan, Senator Casey, for this opportunity. The system to protect whistleblowers is broken, and we need your help. The executive branch is hostile. It has no interest in oversight. The judiciary today is not the judiciary of the 1960s. It's very technical. It's very narrow, and it is not hospitable to employees stepping forward. They look at loopholes in the law and turn them into major sinkholes. The only place left is Congress, and whistleblowers, as you've heard from the panels and the witnesses, truly need your help. How bad is it? I could just say, as a lawyer and someone who studied every single whistleblower law in the United States, federal and state, I can tell you that under federal law, the overwhelming majority of employees have no realistic protection. That's just words. Bonatine Greenhouse, whom I have the honor of assisting in her representation, just last week the United States comes into court and says she has no rights under the First Amendment, no rights as a whistleblower. You can report multi-billion-dollar frauds and you have no protections. That's in America, not Iraq. I have the honor of representing the former director of research at a bulletproof vest company here in America, making bulletproof vests for thousands of American policemen, also for people in Iraq, Secret Service, etc. He documented and exposed that these vests would fail. He turned that information over to the government. His name is Dr. Aaron Westrick. He was fired. He can no longer obtain work in the bulletproof vest industry here in America, yet every one of those vests has been taken off the market. A policeman died, another policeman became permanently injured, and he has no work in his field of expertise. That's the state of law in America. There are solutions. The experts and the people who have been working on whistleblower protection, it's straightforward. Universal coverage, fair procedures. The bill attached by Senator McCaskill to the defense authorization is a brilliant first step. It will cover defense contractors. But what we've already heard is that the shell game is played. All of a sudden, Blackwater is a State Department contractor. All of a sudden, someone else is working for the Provisional Authority. All of a sudden, there are 67 different companies showing up. It's those technical loopholes that have turned into the sinkholes. And that's why we're saying universal coverage, be clear, be straight. I want to say that representing whistleblowers, like the people on these panels, has been a true honor. They are American heroes. They deserve the protection of Congress and the American people. There is one old law out there, and when it works well. It's the False Claims Act, originally generated by good old Abe Lincoln and his Congress. And in 43, it was a great law, but it was gutted by Congress, but it came back to life in 86, bipartisan effort. It's been struggling since 86. Where it has worked well. But technical deficiencies, technical loopholes are again strangling that law. Witness Custer battles. Again, Congress has introduced a Corrections Act. That law will go very far in fixing the problems with the False Claims Act. So between the defense authorization and making that cover anyone working in Iraq and False Claims Act correction, this Congress can really deliver for whistleblowers. Thank you.
Mr. Kohn, thank you very much for your work and also for your testimony here today. Finally, we will hear from Alan Grayson. He's an attorney with Grayson and Kubley. He's been a principal there since 1991. Last year, Taxpayers Against Fraud named him the Attorney of the Year for his work representing whistleblowers regarding contract fraud in Iraq. Mr. Grayson, you may proceed.
Honored members of the Senate, I want to thank the committee for its tenacious effort over the past 4 years to bring the truth to the American people about the Bush administration's mismanagement of the war in Iraq. Clearly, the war has gone terribly wrong, and the American people are entitled to know why. Today's subject is the mistreatment of Iraqi contracting whistleblowers. Contracting whistleblowers have a unique place in our legal system. Thanks to the wisdom of President Lincoln, whistleblowers who witness fraud by contractors are deputized at private attorneys general. They are authorized to bring lawsuits in federal court against companies who cheat the government, the taxpayers, and the troops. Under the False Claims Act, the Attorney General is supposed to join with whistleblowers to prosecute and punish war profiteers. The sad truth is that the Bush administration has not even tried to do this. On the contrary, it's done all it could to prevent this. The Civil War was the original inspiration for the False Claims Act, and the war in Iraq has lasted longer than the Civil War. Yet the administration has not actively litigated one single case of fraud or even breach of contract against any contractor in Iraq. Iraqis have looked on in disbelief and then in anger as one botched Iraq reconstruction job after another has been paid in full, and they see that this administration would even protect our own troops from cheating and overcharging. And many Americans feel the same anger. According to an upcoming article in Vanity Fair magazine, whistleblowers have filed dozens upon dozens of lawsuits trying to prod the Bush administration into fighting contractor fraud in Iraq. For years, the administration's response was to obtain one court order after another, barring whistleblowers and their attorneys from even discussing these cases. In other words, preventing them from telling the truth to the American people about the war in Iraq. Indeed, the Justice Department went so far as to convene a grand jury to investigate whistleblowers and their attorneys for supposed violations of these orders. To their credit, the federal courts were unwilling to go along with this pretense forever, and thanks to our independent judiciary, a dozen whistleblower cases have now been unsealed. The Bush administration has refused to join in every one of them. 5 of those cases remain in litigation, and I am the whistleblower's attorney in all 5. In every one of those cases, the Bush administration has taken no action to punish the war profiteers or recover any of the money that's been stolen from the taxpayers. The False Claims Act also gives the federal government the authority to bring lawsuits to protect contractor whistleblowers who lose their jobs. The Bush administration has never brought such an action, not even once. More recently, we've seen a pattern emerge that is, if anything, even worse than before. the Bush administration is now settling cases of fraud for pennies on the dollar, ending any chance of bringing those war profiteers to justice. The grand total of what the Bush administration says it has recovered through such settlements in whistleblower cases after 4 years is $14 million, which is less than what the Bush administration spends on the war in Iraq every 30 minutes. In another case, the Bush administration required Halliburton to pay back only 1/4 of what an official audit by the Defense Contract Audit Agency found that Halliburton owed, leaving Halliburton with a fraudulent profit of $150 million. It should be noted that the Defense Department itself has been vigorous in its efforts to protect its own troops from war profiteering. It has debarred dozens of contractors from future government contracts. The problem has been that the Bush administration Justice Department won't do anything to recover the stolen money, much less punish the wrongdoers. During the entire period of the war in Iraq, the person within the Bush administration responsible for deciding what to do about the staggering number of whistleblower complaints pinpointing fraud in Iraq has been the Assistant Attorney General of the Civil Division, Peter Keesler. The Senate should note that Peter Keesler is a founder of the Arch Conservative Federalist Society, and since joining the Justice Department, Keesler has not only stifled the Iraq whistleblower cases, but also reduced tobacco company settlements from $130 billion to only $10 billion, defended the Bush administration's wiretapping program, and led the Bush administration's efforts to deny habeas corpus rights to Guantanamo Bay detainees. President Bush nominated Keesler 3 times to federal circuit courts without success so far. Keesler announced his resignation, effective yesterday, but instead, President Bush elevated him to acting Attorney General. Hence, it seems likely to continue that whistleblower cases against corrupt war profiteers in Iraq will go nowhere and that they will not be seen or heard by anybody. One day, there will be a head of the Justice Department who will permit career civil servants to protect whistleblowers, fight war profiteers, and dispense justice. But until then, I urge the Senate to exercise its own constitutional authority and try, with the power at its command, to try to set things straight. Thank you.
Mr. Grayson, thank you very much. The testimony about contracting in Iraq, about the treatment of those who have disclosed activities that are illegal or unethical in those contracting activities is troubling testimony. And I take no joy in being involved in a hearing that talks about failure. I would much sooner trumpet success, but regrettably that has not been the case. There is this issue of contracting. As I indicated, we have held many hearings on the subject. We've had people come and testify about contractors paying $40, $45 for cases of Coca-Cola, having bids on laundry and taking always the highest bid, bids on contracts to produce ice, taking always the bid that was not just higher but much higher, ordering 25 tons or 50,000 pounds of nails. They're delivered to the wrong size. They're now laying a pile on the sands of Iraq. Doesn't matter because we'll just order the right size. The taxpayers pay for the mistake. You know, the list just goes on and on and on. The Custer Battles story it continues to perplex me. There was such substantial evidence of criminal behavior and so little interest in prosecuting it. And I don't understand that. I just do not understand it. We had a doctor, a physician from Iraq, an Iraqi physician, come and sit at a table right where you're sitting, Mr. Grayson, on the right side. An American company got a contract to build and rehabilitate neighborhood health clinics in Iraq. I believe the contract was $200 to $220 million. The money's gone. Those health clinics don't exist. There were, I think, out of some 200 that were supposed to have been built or rehabilitated, 20 were done, the rest were not. The physician, a courageous fellow from Iraq, came to us. He said, I went to the Interior Ministry of Iraq, or excuse me, the Health Ministry of Iraq, now that all that money has gone to this contractor, and I asked him, I'd like to go look at all these 200 health clinics. I want to see what was done. And the Iraqi health minister said, well, you don't understand. Most of those health clinics are imaginary. The money that went out of the taxpayer's pocket in this country wasn't imaginary. It went from taxpayers to the contractor, and now it's gone. But the health clinics that our country decided we were going to produce to help Iraqis did not get built. I mean, the list is endless. I could talk at some length here about all that I have learned and heard, and seen, and it is not what people expect of their government. And failure this is not about politics. It's not about one person. It is about a government that is, in my judgment, not responding to the taxpayers to provide the accountability it should provide. And I do not understand it. Let me just read to you something that was in USA Today, in today's paper. And it relates to something that Senator Wyden and I have been involved in. With all this money being spent over in the Pentagon, they want to hire people, they want to hire other companies to provide oversight with other companies. You can't do that. You can't delegate responsibility, and you can't do that. And so here's today's newspaper, USA Today. Robert Raggio quit his $97,000 a year government job as finance manager for the Iraq reconstruction effort in September 2005. He said his resignation, on his resignation form, he wanted to pursue other opportunities. The same day, his newly formed company, Reviewer Management International, received a U.S. contract to audit $7.3 billion in Iraq reconstruction spending, according to Army documents obtained by U.S. Today under a Freedom of Information Act. Before he quit his government position, he wrote the requirements for the federal contract at the same time he negotiated to obtain it for his company, according to documents. Now, this is the federal government, aside from the wrongdoing here, which is significant. The federal government's hiring a company to oversee. It's the federal government's responsibility to oversee what's happening to all this money. And I find this stuff just unbelievable. It's depressing to be sure. It seems to me the best way to disinfect our government is to expose it to sunlight. And whistleblowers do that. Mr. Isaacson, you've done that. And my guess is that just given the philosophy that you've described of your own life, you probably didn't take a long time to think through, should I do this or shouldn't I do it, and what are the consequences? You did it, and your government owes you a debt of gratitude. Exposing this kind of thing is very, very important. And I know that you are disappointed, as am I, at the way the government responded to it. That's not the government that I'm proud of. This government needs to be better and do better. And Bonnetain Greenhouse, you took the same actions and have risked your career. The actions taken. The reason I called General Ballard, retired General Ballard, one night here not too long ago at 9 o'clock at night and tracked him down at his home is I've long been troubled by what happened to you. There's something wrong, and I've raised it with defense secretaries. Nobody seems to be willing to confront the question. What happens to someone who has the courage to speak out? And if what happens to them is wrong, who's going to take action to set it right? And on the previous panel, when we hear a Donald Vance who, like Mr. Isaacson or Bonnetain Greenhouse, comes forward and is put in prison for 97 days as an American citizen, and his rights are withheld, his constitutional rights are abridged by his government. All of us ought to be very concerned about that. It's hard for me to put into words how strongly I feel about this issue. I don't even think the term whistleblower is a very good term. In some ways, whistleblower kind of, it's almost can be a pejorative term. These are courageous citizens who come forward with information at their own risk. Maybe we ought to change the term here, but we certainly ought to expect the government to own up to its responsibility to protect people that do this. If we don't do that, shame on us. And part of the reason for these hearings is to, again, provide some sunlight and some information and some hopefully some incentive and some determination on the part of this Congress to say something's not right and we intend to fix it. I want Americans to be proud of their government. I want our government to work. In many areas it does, but in this area it has failed miserably. I understand the old saying, bad news travels halfway around the world before good news gets its shoes on. I understand all that. I watch the news in the morning. I know what works on the news, bad news. And I also know there are plenty of good things in our lives and there are some good things in our government. I understand all that. But this is very important. This is about people dying. This is about money being stolen from American taxpayers. This is a very important issue, and we need, as a United States government, to get this right. We've gone through a period now where billions and billions and billions of dollars have been spent in a big hurry. Pallets of cash to Iraq, $100 bills distributed out of the back of pickup trucks. So do we think there's some graft and corruption? We know it. And when those who have the courage come forward to describe it to us, we ought to celebrate that and help them and not ignore them and not hurt them. And so I want to thank all four of you. Let me call on Senator Casey.
Mr. Chairman, thank you. And I can't say enough how much we appreciate you calling this hearing, and the same goes for the witnesses. I think you're right about the sometimes the terminology doesn't do justice when you're fighting fraud and you're standing up to powerful interests. It's one thing to be a whistleblower, but it's another thing to take on the opponents or the targets of your integrity that you've taken on. This isn't just some rogue boss in a small company. You're taking on very powerful people in the federal government, and that speaks volumes about your character. I don't know how much time we'll have to get to the lawyers. I'd love to have more questions. If I don't, I'll try to catch up with you and submit them for another time. But I wanted to just make a couple of, Mr. Chairman, I don't know whether you can do questions now or?
Let me recognize you for questions, Senator.
Okay, thank you. Ms. Greenhouse, I wanted to start with you, and you testified this way already, but I just want to repeat some of what you said. You had worked in the federal government for 23 years?
For 23 years, yes. Yes, sir.
You've got a master's degree in engineering management, a master's degree in national resources strategy, and a master's degree in business management.
That is correct.
And graduate of the Defense Senior Acquisition course, on and on and on in terms of your qualifications and your commitment to public service. And what really struck me, I guess, and it's not just emotional, it struck me, I guess, in light of what we all witnessed in the aftermath of Hurricane Katrina. I think a lot of us believe, I certainly believed and have said it in the past, and as others around our country understand this as well, that we saw a kind of devastation there that was almost unimaginable, not only because of the natural disaster, but because of abject failure by the federal government to respond. We can talk about other levels of government, but the federal government bore most of the should bear most of the responsibility for that. And I've said before that, when you talk about devastation, that devastation doesn't just come with the awful swiftness of a hurricane. It starts a lot earlier than that. Right. And I think we can better understand, tragically so, but we can better understand why the failures of government started long before the hurricane hit. When you say, with all of that experience in the federal government, all of that know-how, and then you add to that you were excluded from the Katrina management meetings, even though you were born and raised in Louisiana, that speaks volumes about what this administration didn't do long before Katrina, but certainly in the aftermath. So it was a continuing failure by the federal government that started years before. Failure to invest, failure to make sure that government agencies can respond. So that's just by way of a statement. I don't ask that as a question. I wanted to ask you, though, about in particular about the contract. The so-called KBR, Kellogg Brown and Root contract. You're talking about a $7 billion, I know this is on the public record already, but $7 billion sole source, no compete, cost plus contract to a Halliburton subsidiary. Tell me about that. And we saw your statement earlier about the, you categorize as the worst example you've ever seen. I'm paraphrasing, but tell us about what normally happens when a contract of that size or that dimension comes before any government agency, but in your experience in terms of the Army Corps of Engineers. Tell me what the process that is usually undertaken when that contract is presented to that government agency.
You have to understand that the contracting officer is the only people that are in charge of obligating the government. And they must play a critical part in developing the strategy as to how we are going to outsource our requirements. And they must be there up front. They must have a sense of interdependence and a sense of independence, to make those critical decisions about what is in the best interest of the government. The government spends a lot of money after Congress passed the law under DAWIA, Defense Acquisition Workforce Improvement Act, just getting a lot of people master's degrees in order that they could have that business acumen, that keenness in making the business decisions. I think what we've got to do with contracting is to decide that we're going to have to correct and reform some systemic problems that are in the pre-award as well as in the post-award, management, of the contracts. There is a civil-military relationship that is broken. That culture and mentality that says the puppet mentality cannot be tolerated. You've got to have an interdependence of authority and making sure that the contracting officer is held accountable for making the best decisions as possible for our government. Specifically in the KBR, type a contract as it were, I had a lot of problems with the legality of that particular contract and all of the contracts that were related to it, because it seemed to have been grossly pre-selection. And to say that the contracting person, say particularly in that the Corps had the executive agency for this particular contract, and I was not included in the beginning of the planning and the strategies for this. I was only brought in when I had to be brought in because I also was the competition advocate. So there could be no bid sole source contract unless I had reviewed it and signed it. Know one thing, I have no aversion against sole source contracts, but I have a responsibility that I must validate that they are sole source. In that particular contract, I felt that there was a conflict of interest to have as part of the justification that the contingency plan that was prepared sole source by KBR a year or so before was part of the justification for the award of the contract. That was a government imposed to me uniqueness, and not a uniqueness that came from that company. If I were to delineate all of the reasons for the one and only one source, they appear to me to be government-imposed uniquenesses. That was a concern of mine. The duration of the contract was a concern. There is no emergency in the world, that requires 5 years or 2 years base and then 3 years options to until you can get to the competitive nature. We've got to demand competition in what we do. And we can't tolerate, and you've got to give the procurement people and have enough confidence in them that competition is not going to take years or months. Competition can take hours because we have the business acumen to be able to do that. So those are a few of the concerns, that I had. The duration of the contract, 1 year. It certainly panned out to be that. After I wrote my statement, that we needed to do better than that to get back, and that statement surely was a protection for all of those contractors out there who never got a chance to know that the requirement was there. That is not the way our business is. Our business is based on competition. Our business is not based upon classification, because there's more than one company who has security clearances to be able to discuss with us, what it is that we might need to do in order to meet our requirements. Emergency should not be that the sky is falling. Allow the contracting people to come into this and make sure that we put the highest degree of business acumen in place. I took an oath of office, and under that oath of office was saying that federal procurement and contracting must be conducted with the highest degree of integrity, the highest degree of impartiality, with preferential treatment toward none. I took that oath seriously.
I wanted to ask you, and thank you for outlining some of the process, because that's important here. How we do this is very important. But I wanted to ask you a broader question, and maybe
Yes.
one or two specific questions, and I've got to run out the door. But the broader question is this, in your judgment, just with regard to this $7 billion contract, but others it apply to as well, just with regard to this contract, is it more of a problem of the process needs to be revamped, or is it the way the rules of the road or the process is enforced? In other words, government officials just saying, well, we don't have to worry about that requirement, or is it a combination of the two?
Well, part of my alleged non-performance is that I'm a stickler to the rules. And if Congress is not happy and feel that the rules don't apply, as far as the contingencies that we are involved in and the selective engagements that we are involved in, you need to change the rules. Because of the fact that when we, as contracting officers, we are the only one who have penal damages, to us with regard to not performing the stewardship that we have. And all it takes is a hotline call, to make sure that that is, regardless of what the military may be telling you to do. And part of our principal assistant responsible for contracting, remember the laws of contracting are not made in the agencies. They are made by Congress. We are there as those senior procurement executives to make sure, to serve as honest broker, to make sure that the compliance is there to the letter of the law. Sure, we realize that there are some gray areas. We realize that there are some emergencies that require some extra consideration, but we never have to break the law in doing that. We never have to defy what federal government expects of us, of being the highest degree of integrity. I just simply believe that integrity in government is not an option.
I'm going to end there. I have to run, but that's a great way to end. Thank you. And I appreciate your service, and I appreciate the panel. I'll try to submit some written questions. Thank you very much.
Senator Casey, thank you very much. Mr. Isaacson, tell me, when you brought evidence of what you felt was criminal behavior of the Custer Battles Corporation to the authorities, tell me again the reaction of authorities.
Well, the FBI and the Department of Defense CID department investigated, and they continue to investigate.
Did you push your button? Thank you.
And they continue to investigate. They have presented their cases to the U.S. Attorney's offices, and nothing has happened. We have met with them on a number of occasions. They've interviewed us, et cetera. They observed the trial in great detail, which was, in my judgment, dramatically more evidence than you would ever need to bring an indictment for fraud. They took copious notes of the trial, but nothing's ever happened. They refused to involve themselves in the KETAM action, and I believe the agents are completely frustrated with those actions. That's the indication that I've gotten from them. But nothing to date. After 4 long years, It still sits in the files of the Department of Justice.
Mr. Kohn, what do you make of that? You're an attorney. What's your sense of what's going on there?
The laws need to get strengthened, period. I just think it's an interesting observation that I'm talking about protecting the whistleblowers, but I think it's so clear from the witnesses that it's really the public that benefits from the whistleblowers. It's the public that benefits when people stand up and point out this fraud, point out the corruption, and stand up to it. It's really the public needs the whistleblower protection. And as I mentioned, there's an excellent law was just introduced, the False Claims Correction Act, which would strengthen his case and actually reinstate it. And the McCaskill Amendment is right there protecting defense contractors. We're inches away from a law, if slightly expanded, just to cover all the contractors, so there's no more shell games here. We're close to a law to defend the contractors. There's the two barrels to winning this fight. Defend the contractors so they can report the misconduct, and strengthen the qui tam law so you can hold those contractors financially accountable. We are close, and I just hope that this Congress can just push us over.
Do you mean defend the contractors or defend the whistleblowers?
The whistleblowers who work for the contractors.
Right.
We have to defend them so they can bring the information forward and not lose their careers. And then we have to strengthen the law that actually holds those contractors accountable dollar for every dime they misspend. And we're close.
My assumption is the experience that has been described to us today by several people would not be encouraging to other employees of contractors who see abuse, who see criminal activity, and might be inclined to report it, but then see, you know, there's substantial cost here to my career, to me, to my family, to be doing this. Is that?
Yeah. You know, I finally came to the conclusion that whistleblowers must not read the newspapers or follow television shows. I mean, why would someone come forward? But they still do. I mean, the National Whistleblower Center gets well over 1,000 requests a year. People are stepping forward, and we have the hard time of saying, well, you know, you may not win. And that's tragic.
I want to thank this panel for being here. I have another engagement that I have to be at as well. We will very likely submit some additional questions to all of you. I thank you, Ms. Greenhouse, Mr. Isaacson. Thank you for your courage. Thank you for your testimony, Mr. Kohn, Mr. Grayson. And this hearing is adjourned.
Thank you.
Thank you.